wasn't a silly mistake. You took merchandise, Mr. Sutherland, and you were not intending on paying for that merchandise.
Right. I feel like that's silly.
Stupid.
Well,
Not silly. It's
I
stupid.
didn't. Right. I just didn't know that that was a word I could use in here.
Oh yeah, you can use stupid because it was a stupid mistake.
Correct.
And it really, actually, it wasn't a mistake. Makes a mistake is something that is kind of beyond your control. You knew what you were doing. Why in the God's green earth? You've been here multiple times before. You've been through treatment court. You've done these things. What on earth was going through your brain at that time where you're like, this is okay? We will go on the record in the matter 25 CM 202, State of Wisconsin versus Trent Sutherland. The state appears through Assistant District Attorney Jose Vila in person. Mr. Sutherland appears in person with his counsel, Amber Sherwood. We're set today in this matter for a status conference. Ms. Sherwood, please update the court.
Yes, Your Honor, we're looking for a plea and sentence date. I have given the state proof that Mr. Sutherland is working, and we have an offer for 10 days in jail that can be done on electronic monitoring with proof of a job.
Okay. Would we be in victims' rights compliance today?
Yes, Your Honor.
We could move forward here today and do a plea.
You want to do that today?
A certain amount of days to get the monitor.
We can do that if you want to if you'll give me a moment to get the plea questionnaire filled out for you, Your Honor.
Good.
Awesome. Come with me.
Thank you. We'll adjourn for a moment. Back on the record, same appearances as previously noted. Ms. Sherwood has now gone over a plea questionnaire waiver of rights form with Mr. Sutherland. Mr. Sutherland, do you understand everything that's contained on this document?
I do.
Your attorney went over with it to you word for word?
Yep.
And you understood everything?
I did.
You signed the document?
I did sign. Yep.
You're pleading guilty to 1 count of retail theft. You're 33 years old. You have 12 years of schooling. You can read, write. You understand the English language. No drugs, alcohol, or medications or mental illnesses or disorders?
No.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
She did.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page. Did your attorney thoroughly go over your rights with you?
Yeah.
You understand them completely?
I do.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around October 1st, 2025 in Burnett County, Wisconsin, you intentionally took and carried away with merchandise held for the resale from Daryl's Hardware Inc. without consent of that merchant and with intent to permanently deprive that merchant of that item's value? Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yeah.
You also understand that there's an agreement here for 10 days of jail with the ability to serve on electronic monitor with Huber release. Do you understand I'm not bound to follow that agreement?
Yes.
Said differently, I could sentence you all the way up to the maximum penalty if I thought it was warranted. You understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
I do.
Did you go over the criminal complaint with your attorney?
Yes.
There's that section called the probable cause section where it basically says what happened that day and why you were charged with the crime.
Yeah.
For the most part, are those facts accurate?
Yes.
Admitting here today that you in fact are guilty of an attempt or a retail theft, even though the property was originally then returned to the merchant?
Yeah.
And so you were intending on taking that merchandise without paying for it?
Correct.
All right. Ms. Sherwood, may the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis?
You may, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty today?
No,
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
yes, ma'am.
and voluntarily.
Correct.
Has your attorney represented you competently?
Yes,
Has she answered all of your questions?
yes,
Has she looked at this matter thoroughly?
I believe so.
Are you satisfied with her services?
Yes,
Any questions for the court or for your attorney before we proceed?
no, ma'am.
Then as to the only count, retail theft as misdemeanor, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the criminal count. Judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. I would ask the court to adopt the joint recommendation. While, as the court already noted, the items were returned to the property owner. The reason for the 10 days jail here is because of Mr. Sutherland's extensive criminal history. Now, to his credit, he hasn't gotten any criminal convictions in the last 5 years. However, because of the extensive history, this needs to be either a probation or a small punishment kind of case. In lieu of probation, the offer is 10 days jail. Now, given the fact that he does have a job, that was part of the reason why we extended the offer of having the monitor so that he could continue to be a productive member of society. With that, I would ask the court to adopt. Thank you.
All right, Ms. Sherwood.
Yes, Your Honor, we're asking the court to adopt the joint recommendation. Mr. Sutherland does have a job at North Star Hydrovac that is a union job and getting his heavy machinery license. He supports 4 children full-time and 2 children every other weekend. Your Honor, we're asking that he be allowed to do electronic monitoring so he may keep his job, may keep his kids a house over or roof over their head and fed. He is here taking responsibility for what he has done, and we're asking that you follow the joint recommendation. Thank you.
Thank you. Did you file taxes this year?
No, not yet.
And that's your plan? You're going to?
I hope so, yep.
I mean, it's the law, literally. You're
Yeah,
working, so you have to, or you can deal with the IRS.
no, thank you.
Okay, so that's your plan. Anything you want to let me know and to tell me?
No, I mean, other than it was just a silly mistake and obviously a regretful action.
It wasn't a silly mistake. You took merchandise, Mr. Sutherland, and you were not intending on paying for that merchandise.
Right, I feel like that's silly.
Stupid.
Well,
Not silly, it's
I didn't,
stupid.
right, I just didn't know that that was a word I could use in here.
Oh, yeah, you can use stupid because it was a stupid, dumb, stupid mistake. And it
Correct.
really, actually, it wasn't a mistake. Makes a mistake is something that is kind of beyond your control. You knew what you were doing. Why in the God's green earth? You've been here multiple times before. You've been through treatment court. You've done these things. What on earth was going through your brain at that time where you're like, this is okay?
Well, I guess I'm not sure. Just, obviously I wasn't, using my head. I wasn't thinking about it.
You weren't. And that's concerning because of all from where you were to where you are here today at having the ability to have a union job, to be sober and to be on a good path and to have your kids with you and, to have the life that you are now in that you have in position right now versus where you were 5 years ago. You almost threw it down the toilet. Obviously, jail wasn't enough to have you think twice about committing a crime of stealing, taking things that aren't yours without paying for them. And I don't want to see that happen again. You are beyond that, Mr. Sutherland, or you should be.
I believe I am.
With this, I think a 20-day jail sentence is appropriate. So I'm sentencing you to 20 days of jail. I will give you the ability to have a monitor and sit that on the monitor. Because I don't want your children to suffer. You have to prepay the monitor before you can be able to be on the monitor. I will give you 20 days to be able to, so it's 2020, so you'll understand how many days you serve and how many days you have until you turn yourself in and then be hooked up on the monitor. But you have to have the money prepaid. And you can work that out with Ms. Anderson. It tests you 24/7. You can't take it off. It's on you until it's removed from Mr. Hatch. The court is also going to assess $500 in fines and fees. You have $500 in court costs. You have $500 posted. You're good to go there. You have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. You're only able to go to work or doctor's appointments or any AA or other treatment type of programming or therapy. If your kid is graduating from kindergarten, you can't go. If you have a funeral, you can't go. Anything that is out of the realm with regards to Huber, to your work, and to doctor's appointments and treatment, you must specifically ask the court if you're able to go. But I'm going to tell you, I've denied graduations before because you committed the crime. You have the penalty. You have the punishment. And here, Mr. Sutherland, you should have known better. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You need to go to the jail and make sure that they have your DNA. If they do, they'll send you on your way. If they don't, then they'll take it and you'll be good to go. You have 20 days to report. That means you have to make arrangements with Ms. Anderson to be able to get the monitor and then report to jail within 20 days. On the 21st day, you could get charged with escape of felony. Okay?
Okay.
Very important that you figure that out.
Who is Miss Anderson?
Tessa,
Oh, okay. Okay.
contact Tessa and she'll go over all of that with you. I believe that covers everything. Mr. Vila?
I would agree, Your Honor.
Well, does he have jail credit?
No, Your Honor.
Okay, so anything else, Ms. Sherwood?
No, nothing from the defense.
Okay, then we are adjourned. You can come get your document. I will. Do you need a document for your DNA? Yes, you should need your document for your DNA. Then go give your DNA and then you're good to go. Contact Tessa.
Okay.
Okay?
Yeah. Have a phone number?
I do not. You're gonna have to figure that out.